Okay, let's unpack this. We're diving deep today into a work that, honestly, fundamentally challenges some of our most basic assumptions about how we're governed, about liberty itself. It's Bruno Leoni's Freedom and the Law.
Ah, yes, a classic.
Exactly. It came out of lectures he gave back in 1958, so it's got some history, but wow, it feels incredibly relevant. It's foundational in classical liberal thought.
It really is, and his core argument is, well, pretty radical. Leoni basically looked at the modern world, especially post-war, with this huge expansion of state power, and he didn't point the finger primarily at dictatorships. He looked at democracies, and he said the biggest threat to the rule of law, the biggest threat to real freedom, wasn't some tyrant waiting in the wings. It was something much closer to home.
Which was?
Over legislation, just the sheer volume, the constant churning out of laws and regulations in our own democratic societies. He argued we're drowning in them and it's stifling us.
That's such a paradox, isn't it? Because the common thinking is exactly the opposite. More laws equals more protection, more clearly defined rights, more freedom.
Right. That's the assumption, law equals freedom.
But Leoni just flips that completely on its head.
Completely. He argues that this assumption is precisely the problem.
So our mission today, really, is to dig into that, to explore his central idea that genuine liberty doesn't come from politicians enacting commands from on high.
No, it relies on what he calls discovered law.
Rules that just sort of emerge organically from how people interact, from customs, from judges, figuring things out case by case.
Exactly. Law is discovered, he says, not made. And if you look at the legislative explosion we live under now, well, it seems pretty clear which path we've taken.
And the consequence, in his view.
A massive creeping suppression of individual freedom.
Here's where it gets really interesting, I think, because Leoni says before we can even understand this threat properly, we have to grasp a fundamental confusion we all seem to make. We're mixing up two totally different things, law and legislation.
Yeah, that distinction is absolutely crucial to his whole argument. And he calls the current situation where we equate the two a kind of silent revolution.
How so?
Well, think about it. For most of legal history, especially in the West, the idea that law had to be written down by a legislature, that would have seemed strange, even absurd. Law was custom, it was precedent, it was judicial reasoning. But today, ask anyone on the street, ask a first-year law student, what is law? And they'll almost certainly point you to statutes, to codes, to regulations passed by Parliament or Congress.
So legislation has basically swallowed the whole concept of law.
That's the revolution. It's been quiet, incremental, but decisive. Statutory law, administrative rules, they're constantly pushing out the older forms. Customary law, civil law traditions based on precedent, common law. They're losing ground every single day.
And you see the practical result everywhere, just mountains of paper.
Absolutely. Look at continental Europe. You have legal systems built on centuries of Roman-derived civil law, this incredible bedrock. But now it's being buried under thousands upon thousands of new specific statutes every year.
And in places like the UK or the US.
Same story, different flavor. Common law, built on judicial precedent, is fighting a losing battle against the sheer volume of administrative decrees and legislative acts coming out of government agencies and legislatures.
It's like this constant informational static, this noise that we've convinced ourselves is reliable order.
That's a good way to put it. Leoni wants us to cut through that noise. So let's define his terms carefully.
Okay, what is law for Leoni?
For Leoni, law with a capital L maybe is this complex web of rules that governs how ordinary people behave. But the key thing is how it arises.
Right, not from the top down.
It's the result, he says, of countless spontaneous actions and decisions by huge numbers of individuals converging over long periods of time. He calls it a secular process. It unfolds across generations, not election cycles.
So it's organic, it's bottom-up, it's social. He uses some interesting analogies, right?
He does. He compares it to language or fashion.
How so?
Well, think about grammar or vocabulary. There isn't some central committee that votes on which verbs are allowed this year or decrees new sentence structures.
No, it just evolves. People start using words differently, new phrases catch on.
Exactly. It emerges from this continuous voluntary collaboration among millions of speakers. Fashion is similar, trends emerge, styles change, but it's not dictated by some ministry of style. It bubbles up from below.
Okay, I see the parallel. So law, in this discovered sense, is like that.
Precisely. And in legal systems that focused on this discovery model, he points to historical Roman civil law or the early English common law. The job of the lawyer or the judge wasn't to invent rules.
It was to find them.
And interpret them.
To interpret. Clarify, they weren't trying to impose what the current majority wanted the law to be at that moment. They were trying to figure out what the law was based on this long, cumulative process of social interaction and expectation. Like legal archaeologists, almost.
Kind of. Discovering, interpreting, trying to make sense of existing expectations, reconciling disputes based on those expectations, not creating rules ex nihilo out of thin air.
Okay, but here's a potential objection. We live in a hyper-complex, fast-changing world now. Digital currencies, AI, genetic engineering, things the secular process hasn't had centuries to digest. Don't we need a legislature to step in and make rules quickly, decisively, where there's no established custom yet?
That's the standard argument, absolutely. It's the main justification given for legislative dominance today.
And Leoni's response.
He'd likely argue that modern complexity actually makes the case against centralization even stronger.
How? That seems counterintuitive.
Because where does the knowledge needed to deal with complex new phenomena reside? It's not in the heads of a few hundred legislators or bureaucrats.
No, it's spread out among users, developers, scientists, business people.
Exactly. It's radically dispersed. In a discovered law system, that knowledge gets aggregated gradually through judges deciding specific contract disputes about crypto or property rights related to AI-generated art. The law adapts incrementally, incorporating this dispersed knowledge as real problems arise.
Okay, and when the legislature steps in instead?
Well, that brings us squarely to legislation. For Leoni, if law is discovery, legislation is coercion.
Coercion, that sounds strong.
It is, but he means it specifically. Legislation is the direct imposition of the temporary preference of whoever holds political power at that moment.
So it's not about finding the existing rule, it's about making a new rule.
Almost always, yes. Legislation typically aims to state what the law should be according to some new policy goal or political agenda. It's often about making a clean break, imposing a novel solution. It's not trying to codify reality, it's trying to command reality into a new shape.
You mentioned earlier this link Leoni saw between legislation and central economic planning. Can you flesh that out a bit more? Why did he see them as structurally similar?
It comes down to, fundamentally, a problem of knowledge and incentives. Think about a centrally planned economy. You have a small group of planners trying to decide what millions of people need, what factories should produce, how resources get allocated.
And the classic critique is they just can't possibly know enough. The information is too vast, too dispersed.
Precisely. Their knowledge is fatally limited. Leoni sees legislation operating in much the same way. When a parliament or a regulatory body imposes, say, a massive 1,000-page bill regulating the entire tech industry, that complex set of rules is based on the inevitably limited knowledge, the specific political pressures, the compromises, and the temporary interests of just a few hundred people in that legislative body or committee room.
And crucially, because it's imposed by force, it's legislation, it's command, it bypasses the feedback loops you get in the discovery process.
Exactly. Spontaneous law, discovered law, it evolves because when rules or expectations don't work, the failure is usually local. A judge makes a bad ruling or a contract interpretation proves unworkable. It gets corrected relatively quickly by other judges, by parties adapting their contracts, by lawyers finding better arguments. The feedback is close to the ground.
But legislation?
Legislation aims for homogeneity. One rule fits all, decreed from the center. It's designed as this tool to force society into a particular mold based on that central, limited vision. And like a planned economy, Leoni argues, it doesn't just fail locally and incrementally. When it fails, it tends to fail big, arbitrarily distorting huge swaths of the legal and economic landscape because it overrides those local adjustments.
Okay, so we have this fundamental split. Discovered law versus imposed legislation. Now, how does this connect directly to individual freedom?
For Leoni, the connection is absolutely vital. His definition of freedom isn't just about, voting rights or free speech. Those matter. Fundamentally, it's the absence of arbitrary constraint by others.
Including constraint by the government, by the authorities?
Especially by the authorities. And the crucial ingredient for this kind of freedom, he argues, is predictability.
Predictability of what?
Of the legal consequences of your actions. If you can't reasonably foresee how the law will treat your decisions, your contracts, your property, then you can't really plan your life. You can't act freely in any meaningful sense. You're constantly looking over your shoulder, wondering if the rules are about to change.
Right. You become hesitant, reactive.
You do. And Leoni traces this modern problem back, interestingly, to an ancient idea. The Greek ideal of law as a precise written formula, the belief that writing laws down makes them certain.
Which sounds sensible on the surface. If it's written down, everyone can see it.
It leads to what he calls short-run certainty. And this is the trap. The law in the books today, the statute, the regulation might be very precise. You know exactly what the tax code says right now. You know the specific environmental regulation you have to comply with this week. That's the short-run certainty. It's clear and recognizable.
But, and this is the core of it, right?
The moment your legal system relies primarily on legislation, you lose something far more important. Long-run certainty. People can never be sure that the law enforced today will still be the law tomorrow or next month or next year.
Because the legislature can just change it.
Anytime. A new election, a shift in public mood, a powerful lobby group, and boom, the rules are rewritten. In a system dominated by legislation, the law itself becomes defined by its potential impermanence, its vulnerability to the whims of the political cycle.
Let's make that really concrete. Imagine I'm an entrepreneur. I want to invest, say, a huge amount of capital in building a new factory, creating jobs based on the current rules about property rights, taxes, labor law.
Okay, the short-run certainty tells you what the rules are now. You can make your initial calculations.
But the long-run uncertainty is terrifying.
It's potentially devastating. Because you simply cannot predict the legal landscape 5 or 10 years out when your investment is supposed to pay off. A future legislature might decide to drastically change depreciation rules, impose crippling new environmental standards retroactively, maybe even favor a competitor with special subsidies or regulations.
So that constant possibility of change hangs over everything.
It does. And when legislation becomes frequent or arbitrary or just massive in scope, it fundamentally changes the relationship between the citizen and the state. You're no longer a free agent planning your life under stable rules. You become more like a subject, constantly forced to react and adapt to the shifting winds of political expediency. Long-term planning becomes almost irrational.
Which leads to this idea Leoni talks about, self-defeating rationality. It sounds rational to have legislators carefully deliberate and write down laws, like Max Weber's idea of rational bureaucracy.
Right. It seems orderly, planned, rational.
But Leoni says this apparent rationality actually undermines itself.
Completely. Because in the long run, this constant legislative churning actively destroys the very foundations of social order it claims to build by eroding the non-legislative rules that people actually rely on day to day. The established customs, the business conventions, the implicit understandings, the long-standing agreements. When the state repeatedly steps in through legislation to override contracts, change property rules suddenly, or impose new obligations out of the blue.
People stop trusting the old ways.
Worse than that, they stop trusting any rules or agreements, even current ones, because they know the legislature might just nullify them tomorrow. The basic predictability, the trust that underpins a complex functioning society, it gets corroded by this endless legislative rationality.
Wow. It's like trying to build a house on constantly shifting sand. You can have the most precise blueprints of legislation, but the ground itself is unstable.
That's a perfect analogy. And it contrasts so starkly with what Leoni saw as the historical ideal, particularly in Roman law, long-run certainty.
What do I mean in practice?
It meant that the fundamental rules of private law, property, contracts, family were considered incredibly stable, almost immutable. They were not supposed to be subject to sudden, unpredictable political changes. This stability wasn't an accident. It reflected a deep-seated, long-run economic mentality.
People felt secure enough to make plans that spanned decades, even generations.
Exactly. They could invest, build, enter into long-term agreements with a high degree of confidence that the basic legal framework would endure. Compare that to our current era. Leoni explicitly contrasts it with the short-term political and economic mindset famously captured by Keynes. In the long run, we shall all be dead.
If the state itself operates on that principle, always focused on the next election, the immediate crisis,
then nobody can afford to plan for the long run. The legal uncertainty created by constant legislation forces everyone into a short-term survival mode.
And this climate of uncertainty also messes with our very language, doesn't it? Leoni points out a crucial semantic confusion around the word freedom.
Yes, this is so important. He highlights this shift, this blurring between the classical definition of freedom, freedom from constraint, freedom from coercion by others.
And a newer idea, freedom from want. Economic security, basically.
Exactly. Freedom from poverty, freedom from unemployment, the right to health care, housing, and so on.
And why is this shift so significant in the context of legislation?
Because guaranteeing freedom from want almost invariably requires more legislation, more state intervention to ensure everyone has a job at a certain wage or access to certain benefits. The state must pass laws that authorize officials to interfere in private economic arrangements.
So to give one kind of freedom from want, you have to take away the other kind, freedom from constraint.
Precisely. You have to constrain employers in how they hire or fire, constrain businesses in how they price goods, constrain landlords in how they manage property, constrain taxpayers through higher taxes to fund the programs. The pursuit of freedom from want through legislation necessarily involves sacrificing freedom from constraint.
It creates an inherent contradiction within the legal system itself.
Absolutely. Leoni uses the example of trade union acts in Britain and the US. These laws weren't just minor regulations. They granted enormous legal privileges and powers to unions, often exempting them from rules that applied to everyone else, such as liability for coercive actions during strikes or the power to enforce closed shops, effectively denying individuals the freedom to work without joining the union. This fundamentally limits the freedom of individuals, both employers and non-union workers, to dispose of their capital or labor through voluntary agreement.
And judges were caught in the middle.
Completely. They were forced by statute to disregard fundamental principles of law, like holding people responsible for coercion or protecting freedom of contract, because the legislation specifically sanctioned these actions for certain groups. The result, Leoni argues, is a legal system at war with itself, where the rule of law means different things depending on which politically favored or disfavored category you belong to.
Okay, so if the modern legislature, with its constant output, is the source of the problem creating uncertainty and undermining freedom, where does Leoni suggest we look for a better model?
He directs us back to history, specifically to legal traditions where law was genuinely treated as something to be discovered, not manufactured. And he sees a really deep connection, more than just an analogy, between this kind of legal system and the free market.
Interesting. How do those connect?
He argues it's no coincidence that the free market found its most fertile ground and achieved its greatest successes in places like ancient Rome and the Anglo-Saxon world. Why? Because these societies operated for long periods within legal frameworks dominated by lawyers' law and judiciary law, respectively.
Systems based on decentralized discovery, not centralized command.
Exactly. They mirrored the market's own spontaneous order.
Let's break those down. Start with the Roman model.
The jus civile was Roman private law. It dealt with the core relationships between citizens: property, inheritance, contracts, torts, family law. The really crucial thing is that for centuries, this vast body of private law was kept largely separate from and immune to direct legislative interference.
So the Roman assemblies weren't constantly passing new laws about contracts.
Very, very rarely. Instead, the law was developed primarily by the jurisconsults. These were highly respected legal scholars, advisors, and writers. Leoni sees their work as the absolute peak of discovered law.
How did they operate? What made them different from legislators?
They approached law almost like scientists. Their research subjects were real-life legal problems, specific cases brought to them. Their goal wasn't to impose a new policy, but to find the right solution consistent with the underlying principles and logic, the ratio. He calls it already implicit in existing Roman law and social practice.
So finding the internal coherence of the system.
Yes. Letting the implicit rules of society emerge, making them explicit, ensuring consistency. When faced with a new situation, a jurisconsult wouldn't just invent a rule. They would painstakingly try to see how this new case fit within the established framework, how it could be resolved in a way that harmonized with centuries of previous understanding.
That sounds like a recipe for incredible stability.
It was. It ensured predictability, that long-run certainty we talked about. They acted as synthesizers and clarifiers of society's accumulated legal wisdom, not as agents of radical change.
And you mentioned a statistic earlier that really drives this home.
It's staggering. Leoni notes that in over 1,000 years of Roman legal history, there were only about 40 significant statutes enacted that directly interfered with private law. 40.
In a millennium. Compare that to one session of a modern legislature.
It's almost unbelievable today. It shows a profound understanding, or perhaps instinct, about the proper domains. Statutory law existed, yes, but it was mainly confined to public law, constitutional matters, administrative organization, criminal procedure. They generally kept the state's legislative hands off the private interactions of citizens governed by the jus civile.
Imagine the confidence that gave people, knowing the basic rules of business and life were essentially fixed.
Unparalleled confidence for commerce, investment, long-term planning. Now, we see a similar, though structurally different, process in the development of English common law.
How did the common law judges achieve a similar outcome without Roman-style jurisconsults?
Common law judges, especially in the formative centuries, also saw their role primarily as discovering the law, not making it. They saw themselves as declaring the existing customs and laws of the realm.
They weren't politicians in robes trying to implement an agenda.
Ideally, no. And crucially, their power was constrained in ways that prevented the kind of arbitrary imposition possible through legislation.
Where were those constraints?
Leoni highlights three main ones. First, judges generally only intervened when asked. They had to wait for a specific dispute to be brought before them by actual parties. They couldn't just decide proactively to regulate a whole area of life.
So reactive, not proactive.
Second, their decisions, their rulings, were technically binding only on the parties involved in that specific case. Now, of course, precedents were set, but the immediate effect was contained. It didn't instantly rewrite the law for everyone in the country like a statute does.
Less systemic shock.
Right. And third, and perhaps most importantly, judges rarely, if ever, decided a case without extensive reference to previous similar cases. The doctrine of stare decisis adhering to precedent.
Looking to the past.
Which forced them into this sort of indirect collaboration. They were collaborating with judges from the past through their rulings and with all the parties involved in those past and present cases. This ensured the law evolved slowly, organically, incrementally, building on what came before.
And that's where the market analogy really comes alive for Leoni.
Yes. This vast, continuous, yet unplanned collaboration among judges, lawyers, and litigants over centuries. It mirrors the way millions of participants in a free market coordinate their actions through prices and voluntary exchange without any central director.
Both systems harness dispersed knowledge and adapt through bottom-up adjustments.
Precisely. Both rely on individual initiative and mutual accommodation to create a complex functioning order. Now, contrast that entire process, discovery, decentralization, gradual evolution, with the nature of political decision-making, especially legislation via voting.
This is Leoni's crucial distinction between market choice and voting choice.
Exactly. Think about how you vote in the market. You use your dollars.
Yeah.
If you want to buy product A instead of product B, assuming A is available, your choice is effective. You get A.
My dollar vote isn't overruled by the majority who wanted B.
Right. Assuming production is reasonably divisible, the market allows for millions of different individual preferences to be satisfied simultaneously. You're never forced into the position of being a dissenting minority whose preference is simply ignored or overridden by the collective decision. Your choice matters directly.
Okay, but voting in a political election or for a specific law?
That's fundamentally different. Political choice, Leoni says, is typically of the all or none variety. When a law is proposed, say, a national curriculum for schools or a new environmental regulation,
the alternatives are mutually exclusive. Either it passes or it doesn't.
Exactly. And if you vote against it, but the majority votes for it, you lose your vote entirely. You are then compelled by the force of law to accept and live under the result you opposed.
That element of coercion is always there in political voting, even in a democracy.
Always. Even if you're in the majority this time, you might be in the minority next time. Leoni's point is that this coercive, majoritarian, all-or-none mechanism is fundamentally incompatible with the way a free market operates, which relies on voluntary, mutually agreeable exchanges and adjustments. A truly free market needs a legal system that mirrors its own spontaneous nature, not one based on centralized command and coercion.
This leads us directly to Leoni's most stark warning, the one that really hits home today. The threat of what he calls legislative despotism.
It's a deliberately provocative term.
It is, and it contains that deep paradox you mentioned earlier. We tend to think that being governed by laws protects us from being arbitrarily governed by powerful individuals.
The old ideal, a government of laws, not of men.
Right. But Leoni argues the modern reality is often the reverse. We are governed by men, Precisely because we are governed by this flood of legislation.
How does that work?
Because when legislative power is effectively unlimited, when the legislature can make or change almost any rule, as long as it follows procedure, it gives the men and women who temporarily control that legislature immense power to interfere in people's lives.
And you can't just appeal to the law to stop them.
Because their actions are the law. The statute itself becomes the instrument of their will, the tool for intervention. It provides the perfect legal cover for what might otherwise be seen as arbitrary power.
So the legislation itself becomes the problem, not the solution. Drives this legislative machine, according to Leoni. What are the political mechanics?
He points very directly at the process of political bargaining, particularly log rolling.
Vote trading, basically.
Exactly. He argues that much legislation isn't the result of some noble pursuit of the common good. Instead, it often resembles a kind of diktat, an order imposed by a temporary manufactured majority.
How is the majority manufactured?
Through deals. Group A wants a specific subsidy or regulation that benefits them, but harms Group C. They don't have enough votes on their own, so they make a deal with Group B, who wants something totally unrelated. Support our measure, and we'll support yours.
So they trade votes to create a temporary coalition large enough to impose its combined will on the minority, the intended victims of each piece of legislation.
Precisely. The specific makeup of the majority might shift from issue to issue, but the underlying dynamic is constant. Some groups use the legislative process to gain advantages or impose costs on others.
There are always winners and losers created by the law itself.
Yes, Leoni describes it grimly as a kind of legal war of all against all. It turns politics into a scramble for privileges and exemptions, sanctioned by the statute book. He even invokes Bastiat's famous definition of the state.
Ah, the great fictitious entity by which everyone seeks to live at the expense of everyone else.
That's the one. Legislation, in this view, becomes the primary mechanism for this mutual predation. It allows people to achieve, through political coercion, what they couldn't achieve through voluntary exchange or production in the market.
And this whole process fundamentally corrupts the traditional ideal of the rule of law, doesn't it? Because we've shifted our focus. We've embraced what Leoni calls a purely formal concept of legality. We've stopped asking critical questions about the content of the law. Is it fair? Is it general? Does it treat people equally?
And instead, we only ask.
Was it passed correctly? Did it go through the proper legislative procedures? Does it have the right signatures?
So as long as the process is followed, the substance can be almost anything.
That's the danger of pure formalism. It allows the legislature, under the guise of legality, to enact laws that are deeply discriminatory or that violate fundamental principles of justice that might have been respected for centuries.
It opens the door to treating different groups of people completely differently under the law.
Exactly. You can create thousands of distinct legal categories. Landlords treated differently from tenants, large corporations differently from small businesses, union members differently from non-union workers, people in one income bracket differently from those in another through highly progressive taxation.
Which shatters the whole idea of equality before the law.
It completely violates the classical ideal of the rule of law, as articulated by thinkers like A.V. Dicey. Dicey's core idea was the subjection of every person, regardless of their rank or status, to the ordinary law of the land administered by the ordinary courts.
But if you have dozens of different laws applying differently based on which category the government puts you in,
then you no longer have one ordinary law of the land. You have a fragmented system of special privileges and special burdens, all legally sanctioned.
And the final piece of this puzzle, the ultimate consequence of this over-legislation, is what Leoni calls official usurpation.
Usurpation of power.
Yes. He reminds us that our freedom isn't just reduced when officials act illegally, when they go against the law. That's the classic image of tyranny. Our freedom is also, and perhaps more insidiously, reduced when the law itself authorizes officials to act in ways that historically would have been considered abuses of power or usurpations.
Can you give an example? Think about administrative agencies today. They often have enormous discretionary power granted to them by statute. Power to issue binding rules, to impose fines, to grant or deny licenses, often with limited judicial oversight initially, right? The sort of thing handled by administrative law. Leoni used some specific continental legal terms here that are quite revealing, didn't he?
He talked about the status subjectiensis of the citizen.
Their position of being subject to the administration rather than equal with it.
And the corresponding eminentia jura of the state officials.
The preeminent rights of the state. Could you clarify what that means in practice? How does eminentia jura allow an official to act in ways that would be illegal for a private citizen?
It essentially means the state and its agents are presumed to have rights superior to private rights when acting in their official capacity. For instance, an administrative body might be empowered by statute to seize property or shut down a business or enforce an order before going to court to prove its case. They act first, and the citizen has to challenge them after the fact.
Which is the complete opposite of private law, where you generally have to convince a judge before you can legally constrain someone else or take their property.
Exactly. When the statute grants officials this preeminent right to interfere based on their administrative judgment or political mandate, it becomes almost meaningless to invoke the law against their actions. The statute is their authority. The constraint on the citizen is perfectly legal.
So your only recourse is often political lobbying, protesting, rather than legal challenge based on stable pre-existing rights.
Precisely. The law itself enables the usurpation. So after diving this deep into Leoni's analysis, what's the big takeaway? What does this all mean for us living in democracies saturated with legislation?
I think Leoni's enduring message, the core warning, is that freedom is fragile. And it's conditional on actively constraining power, all power, including the power of democratically elected legislatures.
Not enough just to have elections.
Not nearly enough. We need somehow to recover that older understanding of law. Law as something that emerges, that's discovered through social interaction and careful reasoning, not just manufactured on demand by politicians. Law as a framework that evolves through voluntary cumulative actions over time.
Because the fundamental tension remains.
It does. The very nature of legislation relying on coercive majority rule to impose a specific will is inherently precarious for individual freedom. It stands in such stark contrast to the spontaneous collaboration and consent implicit in a discovered legal order.
Leoni offers a kind of test, doesn't he? A way to judge whether legislation crosses the line from legitimate rulemaking into illegitimate coercion. He invokes the golden rule.
Yes, it's a powerful benchmark. Do not do unto others what you do not wish others to do unto you. He applies it as a negative boundary for legislation.
How does that work?
Essentially, if a piece of legislation is passed, often through log rolling and backroom deals, that imposes burdens or constraints on a minority group that the ruling majority would never accept if the roles were reversed.
Like targeted taxes on an unpopular industry, or regulations that benefit a politically connected group at the expense of others.
Then that legislation fails the test. It's illegitimate. It's not genuine law, in his view. It's closer to legal plunder, a form of warfare conducted through the statute book.
It really challenges that quote from Montesquieu. Freedom is the right to do all that the laws allow.
It does, because Leoni, echoing an earlier thinker, Benjamin Constant, adds the crucial warning. Laws could forbid so many things as to abolish liberty altogether. The sheer quantity, the constant churning, the unpredictability that is the modern form of despotism Leoni feared.
So changing this trajectory, it seems like a monumental task.
Oh, it is. Leoni was realistic. He knew it requires a fundamental shift in thinking, first among intellectuals and opinion makers, and ultimately in the broader public consciousness, changing the default assumption that more laws equals better society.
But he wasn't entirely pessimistic, was he?
No, he held out some hope, rooted in a kind of pragmatic common sense. He believed that eventually the practical failures of excessive interventionism, whether it's bloated bureaucracies, failed state-run industries, economies choked by regulation, become so undeniable, so inescapable, that ordinary people start to question the underlying ideology. Reality has a way of asserting itself.
Which leaves us, perhaps, with a final provocative thought to chew on. If the modern democratic state sees its primary function, its highest calling, as constantly legislating, constantly intervening, constantly solving problems from the top down, is it possible that the most profound act of statesmanship, the most liberty-enhancing action in our time, might actually be the radical decision to just stop, to dramatically reduce the legislative output, to consciously choose not to legislate, and instead create space for discovered rules and spontaneous solutions to emerge?
That really turns our usual thinking upside down. It prompts a crucial question for you, the listener, as you navigate your own life, your business, your community. Think about the web of laws, rules, regulations, administrative burdens that shape your daily activities. How many of them genuinely facilitate cooperation and predictability, and how many perhaps could simply be removed?
Allowing those older, spontaneous rules based on trust, reputation, mutual agreement, long-run certainty to reemerge and coordinate our lives more effectively, more freely.
Leoni might suggest that the true health of a free society isn't measured by the volume of its statute books, but perhaps by the laws it finds it doesn't need to write.
Well, that's about all the time we have. You've been listening to the deep dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shaped liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.
Bye-bye.